Tonight on the Daily Debrief, in South Carolina, 2 surprises in the case of a woman accused of kidnapping her husband's mistress. And in Ohio, a serial killer stands to address the families of the people he admitted he murdered.
All I can say is that I'm sorry.
But did the judge buy it? Also, in Ohio, the trial of a man accused of murder because of a bar fight. The defense has a different story.
Unfortunately, for the prosecution, they simply just cannot prove their case.
It's been a big day in court. The Debrief has it covered. And good evening, everybody. Welcome to the Daily Debrief. 2 bombshell announcements in the South Carolina case of a woman accused of kidnapping her husband's younger mistress. First, a relative testified that he saw pictures of the victim after she disappeared in a state where she was not able to talk or walk, and those pictures were said to be on the defendant's husband's cell phone. Second, the defendant herself promised to testify. Tammy Moorer is on trial for conspiracy to kidnap 20-year-old Heather Elvis. Questions in court have surrounded whether Moorer's husband, Sidney, got Elvis pregnant and whether that was the motive for the kidnapping. Authorities say Elvis talked about being pregnant and that police found a box for a home pregnancy test among Elvis's belongings. Prosecutors told the jury they have no clue where Elvis might be, but this isn't a murder case. All they're going for is kidnapping. In court today, questions about that bombshell photo of Heather Elvis after she disappeared were limited.
While you were over there, after Heather went missing, did you see a picture of Heather Elvis at that house?
Yes.
And what did you see that picture on? When you saw that picture of Heather Elvis, in that picture, could she move at all?
I don't think so.
Okay. And did it look like she could talk?
No.
And after you saw the picture, what did you do?
Nothing. I didn't know what to do.
Okay. Did you stay at the house or did you leave?
I left.
Okay. And how did you feel when you saw the picture?
I didn't know. I don't know. I really don't know.
Okay. But you left once you saw the picture?
Yes.
Okay. At any point, did you tell the police what you saw on that phone?
It wasn't until later I told.
Did you, after seeing that picture, continue to hang out with Tammy and Sidney?
No.
Attorney Nicole DeBorde is with us tonight to analyze this case. Nicole, this photo that witness talked about could make the case. The question is, does anybody believe that witness? He's got his own criminal history. Is he making sense? Is he credible?
You know, I think that he may have sounded credible up until the point when he found out that he called his mother and said everything that he said was a lie. And that's a huge problem for the prosecution. It makes it look like they tried to trick the jury, and I think this could be very, very bad for their credibility in general in this case.
You know, Moore stood up and told the judge she will take the stand herself in this case. But, you know, a lot of people are criticizing the state's case, saying that the state hasn't proven its case beyond a reasonable doubt. So why is Tammy Moore taking that risk of getting up on the stand and facing a really tough cross-examination if the burden is on the state and a lot of people are really critical of the state?
You know, that's a great question, and I wonder whether or not her attorneys have advised her against testifying, and she's still doing it. I certainly don't know this, but it seems like, from my perspective, and I don't know the case other than what we've seen in court like you, but it seems like a terrible idea. I'm not sure why she's putting herself on the stand for cross-examination. All she can do is make it worse.
Yeah, you know, this is a really interesting one because we have the defendant promising to testify. That promise was given to jurors right at the beginning of the case, Nicole. So, look, maybe this was part of a grand plan, or maybe she was adamant from day one with her attorneys. I am absolutely taking this stand. That's the way I'm going to do it. I'm going to tell everybody that I had nothing to do with this. Maybe she's going to point the finger at her own husband.
You know, it's entirely possible, and it may have been her original plan that she did intend to testify, and it's certainly fine for her to go back and make a different decision now. It is difficult when you promise jurors something in opening argument and you don't deliver. However, I think that she's in a circumstance where it might be worth saying, you know what, we were going to do this, but the state didn't prove their case, and now we've elected to let the case stand as it is. I think it's a mistake for her to get up on the stand and start asking and answering direct questions about where she was and her involvement, what these text messages mean, why she deleted them, and more. It's risk.
Nicole, look, I know we'll talk to you about some other cases in a couple of minutes here. In fact, another case we are following is the Ohio murder trial of Carl Wimpy Jr. Testimony in that case entered its second day today as prosecutors tried to prove murder and assault charges stemming from a fight at a Toledo area tavern. The victim, 59-year-old Daniel Vasquez, died after suffering injuries he received while trying to break up the fight. A different defendant, Arthur Richter, actually picked the fight. Wimpy fought back outside the tavern. Vasquez tried to intervene, so Wimpy fought him as well. It ended when Wimpy threw a punch that prosecutors say ultimately caused Vasquez's death. During opening statements, prosecutors recounted every punch and then said this.
Mr. Wimpy connects with another left hook. Mr. Vasquez goes to the ground. He loses consciousness and he never wakes up. 4 days later, he's taken off the life support and he's lost his life over a nonsensical bar fight.
From there, the state argued that despite the involvement of several people in that fight, it was Carl Wimpy alone who caused the victim's death. Prosecutors also said they do not need to prove intent.
What happens when Mr. Vasquez gets thrown to the ground by Mr. Massad versus 6 punches thrown by Mr. Wimpy that all connect with his head? There's only one thing in the video that renders him unconscious, and that's a punch from Mr. Wimpy. And the state contends that that, in and of itself, along with the other medical evidence that you're going to see, is going to be proof beyond a reasonable doubt that Mr. Wimpy was responsible for the death of Mr. Vasquez. The other issue that defense counsel is going to present is going to be the issue of intent. Whether he intended to cause the death of Mr. Vasquez. The state is not indicating to you, and is not going to argue, that Mr. Wimpy was out looking for a fight. The state's not going to argue that Mr. Wimpy intended to kill Mr. Vasquez.
The defense sympathized with the victim but argued the prosecution could not meet its burden. The defense, too, pointed jurors towards a video of the fight which resulted in the victim's death.
And we don't take that, we want to take away with that by any ways, means, or form. It's unfortunate, and our blessings go to the family of the deceased in this particular case. But unfortunately, for the prosecution, they simply just cannot prove their case. And you will see this throughout the trial. The prosecution has numerous hurdles. And I agree with Brother Counsel that, yes, thank God for us and thank God for the jury that there's video of the entire incident. The number of cameras with different shots and different views. You can see exactly what happened. The only thing you're not able to see is, or hear actually, is what was said during those conversations. But you can tell by the movement, by the gestures, by the hand gestures, and things of that nature, in your mindset what a normal person would think what was going on in that particular bar that evening. Talked about hurdles. The prosecution has this issue called causation. And you'll see in the murder charge, it says proximate result. There's a purpose for that. The purpose is that this defendant killed the individual.
The defense attacked the legal element of causation by going on to argue that this defendant was simply trying to protect himself.
They backed up, and they kept backing up, just to do what? Watch the individual, watch this Arthur Richter, so he doesn't hit him again. But see, that backing up is important, ladies and gentlemen, because guess what? That vehicle didn't turn the back against this person that was assaulting. That's like exactly why he didn't want to turn his back on Mr. Richter, because he knew in his mindset what would happen in that particular matter. He would get hit. So he couldn't just walk away. We're going to be able to show that this defendant acted absolutely in self-defense of himself and self-defense of his individual partner that was there, Mr. Kassad. They were both not the aggressors in this particular case. Please look at that. I think it's going to be undisputable they were not the aggressors.
And today in the case, a coroner testified that punches, not seizure medication, likely caused the victim's death.
Doctor, if somebody's punched in the head 6 times, can that cause a subdural hematoma?
Yes.
And if somebody has a traumatic brain injury, can that result in seizures?
Yes.
And if somebody suffers a brain injury, can that create conditions that could lead to a stroke?
Yes.
With regard to the seizure medication, you have no evidence that Mr. Vasquez was previously prescribed with seizure medication prior to you receiving him for his autopsy, do you?
I don't have any history of that.
All right, and you don't have any history of him having any prior brain injury prior to this particular incident, do you?
That's correct.
No further questions.
Just one follow-up, Judge. Dr. Peter, in your evaluation, you did see a toxicology report, right?
Yes.
And didn't the toxicology report show that there was Keppra, the seizure medicine that was in his system?
Yes.
Attorney Nicole DeBorde, let's break it down now. The state doesn't have to prove intent to kill. The defense bringing up other elements that it's trying to push here. Both sides really trying to jockey the statute to tell jurors, hey, look, we don't have to prove that. We don't have to show that.
Right. No, I mean, it's definitely a situation where this death sort of comes from this unexpected cause. A punch in the face doesn't generally cause someone to die. And so this creates a very unique circumstance for the prosecution. Generally speaking, barroom brawls are very difficult cases for the prosecution. And here you also have potential alternative causes of death that the defense is trying to throw out there as potential reasons. So this is a tough situation.
You know, we keep hearing that video is going to tell the story. And look, folks, I wish we could show it to you at home. Here's the problem. The way it was played in court was nearly impossible for our cameras to see. That said, the video is pretty grainy, and each side has its own version of the story. The defense, Nicole, is saying that this is basically self-defense, that this defendant felt as though he was caught up in this, and then as other people, including the intervening victim, came to fight him, he felt as though he had no choice but basically to fight back. Does the self-defense theory work here?
It certainly could if the jurors believed that he did everything that he could to extricate himself from the circumstance and had no choice but to respond with force so that he wouldn't be harmed. It's very possible that they could acquit him based on self-defense.
And you know, an interesting case here because there is video. The video's not in dispute. It's not in dispute who's standing where in the video. The bottom line is, though, each side is saying there's a different conclusion to be reached from watching the same video.
Very interesting, and sometimes it's all about perspective. So we'll see what the jurors think from where they sit.
We will be waiting to see in that case as it moves into the defense case here. Still ahead tonight, though, on the Daily Debrief, an update from the case of the real estate heir accused of murder in California. Plus, a teenager is under arrest after the brutal beating of a member of New York City's Jewish community. That beating was caught on tape. That's coming straight your way after the break. Welcome back, everybody. A preliminary hearing is in its third day for a real estate heir accused of murdering a woman who had information about the disappearance of his wife. Robert Durst is accused of killing Susan Berman in the year 2000. Prosecutors claim Durst shot her because she had information about the 1982 disappearance of Durst's wife. Durst has denied involvement in his wife's disappearance and in the shooting death of Susan Berman. The hearing came to a halt the other day because the court didn't have adult diapers in stock for the defendant. The purpose of the hearing is for a judge to decide whether there's enough evidence to send Durst to trial. It took Michigan jurors just a couple of hours to find Wendell Popejoy guilty of murder and to select the degree of murder that the defendant was guilty of committing. Prosecutors charged Popejoy with so-called open murder. That allowed the jury the final say on the severity of the charge. Authorities testified that Popejoy confessed to shooting his 59-year-old neighbor after he caught her clearing a driveway with a snowblower. The driveway was the subject of a long-standing land dispute. During the confession, Popejoy said he was not sorry his neighbor was dead. Now for a look at other crimes making headlines, here is Anthony Velez.
Here are today's top crime stories trending on Law&Crime.com and across the country. Authorities in South Carolina reportedly discovered a cache of guns in the home of the ex-Army sharpshooter who allegedly ambushed officers trying to question his son about a child sex assault case. 74-year-old Frederick Hopkins is accused of firing at Florence County deputies with 2 military assault rifles and a pistol as they tried to execute a search warrant and interview his son, 28-year-old Seth Hopkins, who faces charges of criminal sexual conduct with a minor. 1 officer died during the alleged ambush, and 6 others were wounded. Hopkins is charged with murder and 6 counts of attempted murder. An Uber driver accused of kidnapping and sexually assaulting a passenger before dumping her on the side of a Connecticut road was arrested and charged in New York. 24-year-old Habir Parmar allegedly picked up the unidentified female passenger in Manhattan who requested a trip to White Plains. The woman reportedly fell asleep, and Parmar changed her destination to Boston before pulling over. When the woman awoke, she discovered Parmar in the back seat sexually assaulting her. That's when Parmar left her on the side of the road. Parmar now faces charges of kidnapping and wire fraud. A teenager in New York City is facing hate crime charges after being caught on camera attacking an Orthodox Jewish man with a branch. The suspect, 18-year-old Shervy Taylor, allegedly was released from police custody less than 30 minutes before this vicious attack in the Crown Heights section of Brooklyn. Taylor was chased down by multiple witnesses and detained until police arrived to make the arrest. Taylor now faces charges of felony assault, menacing, harassment, criminal possession of a weapon, and a hate crime. Those were today's top crime stories. I'm Anthony Velez for the Daily Debrief.
An admitted serial rapist and murderer learned his fate in an Ohio courtroom this week. Robert Rembert entered 4 surprise guilty pleas just as jurors were supposed to be seated in a murder case against him. Rembert was charged with killing his cousin, a longtime family friend, and 2 other victims. Authorities said DNA helped link them to the defendant. The crime spree for this defendant is said to have gone back to 1997. Today in court, the friends and family of his many victims spoke to the judge.
Just miss my daughter.
I do too. And it's not just the pain he caused with the loss of our daughter. It's our... You know, he killed somebody in the past. He should have never been let out of jail. This is how he thanks the society for letting him out. And I know he has an eligibility for parole. I'll be at every parole hearing and make sure he never sees the light of day again.
He let him stay in our house. We helped him, but this is how he repaid me. And I'm like, I'm trying to get closure for my grandbabies. My grandbabies miss their papa so much. And he took them away. For what? I don't know.
I hope that Mr. Rembert will realize what he's done. You know, she was 5 foot, so I don't think she could have hurt him in any way.
After hearing from all those victims who lost loved ones, the defendant stood and addressed the court with this.
Possibly say it can change what happened and what I did. All I can say is that I'm sorry. And that you just pray for me. I'm sorry.
And the judge who presided over the case spoke directly to the defendant and to the victims.
I'm pleased that you said something today. There's nothing that can be said that can bring back these beloved people. It's absolutely heart-wrenching to hear the impact on kids and grandkids, and that's across the board. This is so sad. I can only hope that there is a healing process that can commence at this time. We can't say closure. It just doesn't seem that really happens, but maybe a healing process. Maybe a guilty plea and an I'm sorry will further that. But I want to thank each and every person in our gallery for their dignity. I will pray for you. My heart goes out to you in your losses. And I want to say, as a member of our community, thank you for what you're doing in stepping up.
The final sentence for that defendant was life in prison with a shot at parole after a couple of decades. Nicole DeBorde, back to you. The judge really trying to help heal a community there.
You know, it sure sounds like it. That was a heartbreaking case, and she's right about one thing. These cases don't bring closure. Certainly the cases end, but it doesn't change any of the misery any of these folks are suffering. You know, the defendant will go on to a lifetime in prison, and the families will still continue to suffer their losses. You know, there's nothing really that a judge can do in these circumstances besides pronounce judgment and move on to the next case. And that's a pretty empty thing for almost everybody involved.
Yeah, that's true. I mean, certainly judges try to do something to bring a catharsis, bring a moment that people can look back on if they lost loved ones to a case like this and say that at that moment things start afresh. And it seems that the judge was trying to do that here. But what about Robert Renbert here, the defendant? Does anybody believe this guy when he stands up and says, "I'm sorry and there's nothing else I can say"?
You know, he may be sorry. Is he sorry for himself because he's stuck there in court and going to prison? Is he sorry for his choices? It's hard to say. And it doesn't matter. He's getting life in prison. And I'm not sure whether or not it will bring the family any comfort other than that he's helped them avoid further litigation in this matter.
So the sentence here is life in prison with a shot at parole after a couple of decades. I forget the exact calculation here because they were stacking sentences up one upon another. Why not something more serious? I think that some of the victims' families probably would have wished for something worse.
You know, there's really no result that's ever going to make this grief less. And the reality is not having to endure the ongoing litigation that happens in these cases is probably worth a life sentence where you know someone is at a minimum going to spend several decades more in prison. If he lives to see his first parole eligibility, they are certainly going to be permitted to protest it. He may never and likely will never get out of prison as a result of this sentence.
Yeah, Nicole, one last question here as we wind down the day on the Daily Debrief here. Have you ever heard of a case against someone being delayed because adult diapers were not in stock in the courtroom?
You know, I am contemplating how I might be able to use this particular motion for continuance in my own cases, and I just can't think of a way, but no, I've never seen it done.
Well, you know, you learn something new every day. Nicole DeBorde, attorney, Houston, Texas. Appreciate you joining us here on the Daily Debrief today. Your insight is always very, very helpful.
Super. Thanks for having me.
And that's it for us today on the Daily Debrief here on the Law and Crime Network. A reminder that Law and Crime will be streaming the trials that we discussed that are going to continue beginning tomorrow at 9 a.m., including the Tammy Moorer case where the defendant has promised to take the stand. That's it for us today on the Daily Debrief and on the Law and Crime Network. For all of us here at Law and Crime, this is Aaron Keller. Have a very good evening.